Now, a major decision has been taken by the Madras High Court that NGT Delhi bench is not the principal bench. Now, what is principal bench and subsidiary benches? Principal bench is like there's a principal bench of Allahabad High Court in Allahabad, ठीक है, उसका एक बेंच अलग है लखनऊ में, ठीक है. तो अब ये जो लखनऊ वाली बेंच है और जो इलाहाबाद वाली बेंच है, क्या किसी लखनऊ बेंच के जजमेंट को इलाहाबाद में जाके चैलेंज किया जा सकता है? नो, बिकॉज बोथ आर हैविंग सिमिलर काइंड ऑफ या सेम जुडिशियल पावर्स, ठीक है. बिकॉज ऑफ द जियोग्राफिकल स्प्रेड, इलाहाबाद हाई कोर्ट का एक बेंच ओपन किया गया या एक ब्रांच ओपन किया गया लखनऊ में. तो सिमिलरली एनजीटी, नेशनल Green Tribunal, was formed in 2010 through the NGT Act 2010. So NGT is what? A statutory body. It is not a constitutional body or executive body. तो NGT के 5 divisions हैं, ठीक है. NGT के 5 divisions हैं. The first one is Central, ठीक है, जिसका हेडक्वार्टर भोपाल में है. सेकंड वन इज नॉर्थ दिल्ली, ठीक है, ईस्ट कैलकाटा, ठीक है, साउथ चेन्नई एंड वेस्ट पुणे, ठीक है. तो ये एनजीटी की 5 बेंचेस हैं अंडर द एनजीटी एक्ट 2010. And there is nowhere a mention of principal bench or subsidiary benches under the original act. That means all these benches had similar power या same power with respect to their territorial jurisdictions. Okay? मतलब to counter the logistical difficulties कि अगर चेन्नई में कोई केस होता है environment related तो people will have to come to Delhi like Supreme Court, ठीक है, कि Supreme Court is only in Delhi. तो अगर साउथ में भी, केरला में भी कोई केस होता है तो पीपल विल हैव टू कम टू दिल्ली टू फाइट दैट केस इन सुप्रीम कोर्ट. टू रिड्यूस दैट, टू रिमूव दैट डिसेबिलिटी, व्हाट एनजीटी एक्ट डिड वाज इट एस्टैब्लिश्ड 5 एनजीटी बेंचेस, ठीक है, एंड 5 ऑफ देम हैड इक्वल पावर्स, ठीक है. अगर सेंट्रल जो कि दिल्ली में है एनजीटी, वो कोई ऑर्डर पास करती है, ठीक है, तो इट विल हैव सेम पावर विद द सेंट्रल वाली जो है वो भोपाल में है एनजीटी, तो इट विल हैव सेम अथॉरिटी एज एनी ऑर्डर पास्ड बाय द नॉर्दर्न या जो दिल्ली के बेस्ड ग्रीन ट्रिब्यूनल है उसके. मतलब ऑल ऑफ देम हैड सेम अमाउंट ऑफ पावर. बट व्हाट हैपेंड वाज इन 2017, ठीक है, इन 2017 central government issued a notification and said that the Delhi branch of NGT shall be what? The principal branch. Principal branch means कि all other branches will be subsidiary to the principal branch of the Delhi NGT. ठीक है. Now what has happened is Madras High Court has stayed the transfer of a case from Chennai NGT to Delhi NGT and struck down the 2017 notification issued by the central government that Delhi is a principal branch and said that all the NGTs have equal power. ठीक है? All the NGTs have equal power. That this is what Madras High Court has said. ठीक है? Madras High Court has stayed the transfer of a case from South Zone from Chennai to Delhi bench citing NGT Act 2010. ये मैंने आपको बता दिया. Now what is NGT? ठीक है? NGT is National Green Tribunal. It is a tribunal. ठीक है? It is a tribunal. What is a tribunal and what is a court? Tribunal does not follow necessarily the laws laid down under the judicial procedures. That is why it is tribunal. ठीक है? A tribunal is formed through, this was formed through NGT Act 2010. ठीक है? It seeks to provide speedy and low cost environmental justice. ठीक है? So one does not need to have lawyer. If you have any issues, you do not need to have a lawyer, and you can directly go to the NGT and file your case on your own behalf. Why? Because it does not follow the civil procedure codes as laid down under the CPC Act 1908. ठीक है? It does not follow the civil procedure code. Now what is civil procedure code? Civil procedure code is a method या एक procedure या protocol है that should be followed while following a civil case. वैसे ही CRPC criminal procedure code, it is a methodology mentioned कि what should be done, what should be standard protocol for following a criminal case in a court. ठीक है, तो civil procedure code follow करने के लिए ये NGT obliged नहीं है. It does not has to follow the civil procedure code that has been laid. Neither it has to follow the evidence act. ठीक है, तो it follows only the principle of natural justice and sustainable development. ठीक है, तो what principles it follows? It follows the principles of natural justice and sustainable development. Okay, its orders are final and binding and cannot be challenged in any high court, but an appeal can lie into the Supreme Court. ठीक है, its order can be appealed into Supreme Court. Now its order final and binding. Then how does a person from south zone of NGT bench gets reprieve from the Madras High Court? तो ये डाउट बहुत बार अराइज होता है कि किसी ट्रिब्यूनल के जजमेंट को कोई हाई कोर्ट में चैलेंज कर देता है, एंड डिस्पाइट द फैक्ट कि ट्रिब्यूनल्स का जजमेंट कोर्ट्स में चैलेंजेबल नहीं है. बहुत सारी कोर्ट्स का जजमेंट लाइक एडमिनिस्ट्रेटिव ट्रिब्यूनल का जजमेंट इज नॉट इवन चैलेंजेबल इन सुप्रीम कोर्ट और इन द हाई कोर्ट्स. ठीक है, तो सिमिलरली तो what happens in those cases is people don't usually go through appellate jurisdiction. ठीक है, they do not appeal. appeal का मीनिंग क्या है? to challenge a judgment of a lower court, ठीक है ना, into a higher court. ठीक है, that is called appeal. appeal मतलब अगर आपको डिस्ट्रिक्ट कोर्ट से कोई जजमेंट मिल गया एंड यू आर नॉट सेटिस्फाइड विद दैट जजमेंट, यू कैन अपील दैट जजमेंट इनटू द हाई कोर्ट. This is called appeal. But in case of tribunals, ठीक है, tribunals like water dispute tribunals, ठीक है, तो water dispute tribunal के जो judgment होते हैं they are final and binding. They cannot be challenged anywhere. So you cannot file an appeal against the tribunal judgment into high court or supreme court. ठीक है, it is final and binding. Still, states go to supreme court regularly, challenging the decision of the water tribunals. ठीक है, and that is one of the major reasons कि वाटर ट्रिब्यूनल्स का जो जजमेंट है उनके इम्प्लीमेंटेशन में बहुत सारे ईयर्स लग जाते हैं. नाउ अगर हम चैलेंज ही नहीं कर सकते वाटर ट्रिब्यूनल के जजमेंट को हाई कोर्ट या सुप्रीम कोर्ट में, देन हाउ कम दिस की स्टेट्स कॉन्स्टेंटली चैलेंज इट? बेसिकली दैट हैपेंस थ्रू अ रिट पिटिशन. ठीक है, रिट पिटिशन, someone from the state files a writ petition against the judgment of the tribunal, and Supreme Court is obliged. ठीक है, High Court is not obliged. High Court can refuse to accept a writ petition. ठीक है, under Article 32, but High Court can refuse to admit any writ petition, but Supreme Court is obliged because Supreme Court is the fundamental guarantor of the fundamental rights in India. So people file writ petitions challenging the judgments of the tribunals. ठीक है, तो अब आपको समझ में आ गया कि अगर किसी ट्रिब्यूनल का जजमेंट, मोस्ट ऑफ पीपल हैव दिस डाउट कि सर ट्रिब्यूनल जजमेंट कैन नॉट बी चैलेंज्ड इन सुप्रीम कोर्ट और हाई कोर्ट, देन हाउ कम द स्टेट हैज चैलेंज्ड? एक्चुअली स्टेट हैज नॉट चैलेंज्ड, स्टेट हैज फाइल्ड अ रिट पिटिशन. अगर स्टेट नहीं फाइल करता तो सम इंडिविजुअल हैज फाइल्ड अ रिट पिटिशन ऑन द बिहाफ ऑफ द स्टेट. ठीक है, तो इन रिट पिटिशंस को हियर करने के लिए सुप्रीम कोर्ट स्टार्ट्स assessing the judgment of the tribunal. This is what happened in this case. The Southern Zone NGT directed the transfer of the case from Chennai bench to Delhi bench because of the existing notification by the central government that the Delhi bench will be the principal bench. Now now Madras High Court was hearing a writ petition filed by the same person whose petition was being transferred from Chennai bench to Delhi bench, and it has removed that, it has struck down that notification, saying that that notification is not constitutional. ठीक है, on the grounds that NGT Act does not include any kind of principal bench, any kind of mention of principal bench. ठीक है, okay. It follows the principle of natural justice. It has power to offer relief. Now it has also power to offer relief or compensation. ठीक है, इट कैन अवॉर्ड कंपनसेशन, ठीक है। यहाँ पे एक इंपॉर्टेंट टर्म है, दिस इज हाउ यू हैव टू रिलेट टू मेक योर स्टडी इजियर। नेशनल ह्यूमन राइट्स कमीशन also has a power of civil court. It is not a tribunal, but it has a power of civil court when making inquiries, ठीक है, and enforcing its summons, ठीक है। But National Human Rights Commission cannot award compensation to the person affected. What it can do, it can recommend to the government to award some compensation, and the awarding of the compensation is based on the discretion of the government. But similarly, National Green Tribunal can not only get into the inquiring into the case, but it can also award a compensation, ठीक है, to the person affected, ठीक है। It can also for the damages caused by the environmental degradation. If someone files a plea in the NGT कि air pollution की वजह से I have suffered this damage, तो NGT if believes that yes, that person has suffered damage due to environmental pollution, it can also award compensation to that, ठीक है। Of course that compensation will be paid from the public from the contingency accounts of contingency fund of India, ठीक है। Now what are the constitutional and statutory provisions? First one is fundamental right. Article 21, right to life with dignity includes access to clean air, water and environment. ये constitutional statutory provisions किसके लिए हैं? For the formation of National Green Tribunal, ठीक है। DPSP Article 48A, again, state shall endeavor to protect the environment and safeguard the wildlife and forest, ठीक है। Again, fundamental duty 51AG, it shall be duty of every citizen to protect and improve the natural environment of India, ठीक है। Statutory provisions क्या है? NGT Act 2010, EPA 1986, एयर पॉल्यूशन कंट्रोल एक्ट 1981, वाटर पॉल्यूशन कंट्रोल एक्ट ऑल्सो। तो ये स्टैट्यूटरी और कॉन्स्टिट्यूशनल प्रोविजंस हैं जो कि विच आर द फाउंडेशंस ऑफ नेशनल ग्रीन ट्रिब्यूनल, ओके। नाउ व्हाट इज द स्ट्रक्चर एंड कॉम्पोजिशन ऑफ एनजीटी? It should comprise of three basic kind of people. The first one is chairperson. Chairperson is appointed by central government in consultation with Chief Justice of India. The qualification should be that the chairperson should either be a judge of Supreme Court or has been a judge of Supreme Court, or should be a Chief Justice of High Court or has been a Chief Justice of High Court. Understood? Both working and retired people can function as the chairperson. Now, judicial members and expert members. Judicial members are people who have experience in judicial exercise. Expert members are people who have experience in environmental laws, who have experience in, who have worked in like activists, ठीक है, who have worked in environmental domain. तो okay, तो chairperson will be appointed by the central government with the help of, in the consultation with the CJI. Judicial members not less than 10 and not more than 20, ठीक है, पूरी bench में there cannot be less than 10 and not more than 20 members, appointed by central government plus chairperson's consent, ठीक है। Central government will consult chairperson and they will appoint judicial members. Qualification is who has been a high court judge, at least जो कि हाई कोर्ट जज रह चुका हो वही इंसान जुडिशियल मेंबर के तौर पे अपॉइंट हो सकता है एनजीटी में। सिमिलरली एक्सपर्ट्स not less than 10 and not more than 20. Again, experts and judicial members cannot be less than 10 and cannot be more than 20. Should have experience and qualification in the technological and scientific or practical experience in the matters of conservation of the environment. ये होंगे एक्सपर्ट मेंबर, ये होंगे जुडिशियल मेंबर। जुडिशियल मेंबर का एक्सपीरियंस जुडिशरी वाला होगा, एक्सपर्ट मेंबर्स का एक्सपीरियंस एनवायरमेंटल एस्पेक्ट वाला होगा, चेयरपर्सन का एक्सपीरियंस जुडिशियल जो एक्सपीरियंस होगा वो होगा। दिस इज द स्ट्रक्चर एंड द कॉम्पोजिशन ऑफ एनजीटी। Okay, there was a minor technical glitch, but still we will continue our very important topic of NGT again. Now we have seen the composition and structure of NGT. Now we will be observing the powers and jurisdiction. ठीक है, तो territorial jurisdiction of course has been mentioned in the NGT Act itself कि northern zone will act for what kind of area? Sorry, eastern zone will act for what kind of area? Southern zone and central zone and western zone. Now, what are the powers and the jurisdiction of the NGT? The first one is any substantial question of law relating to environment. Now, what is substantial question of law? Substantial question of law is that determines the basic of the law. Like fundamental right के बारे में अगर कोई substantial question है ना, that majorly decides about the fundamental right, then the authority lies with the Supreme Court. Okay. Similarly, when there is a substantial question of law relating to environment, the authority lies with the NGT. Has both original and appellate jurisdiction. Now we talked about appellate jurisdiction थोड़ी देर पहले. तो appellate jurisdiction अभी तो हमने जो पढ़ा, that was कि appellate jurisdiction it has both original, ठीक है, original and appellate, ठीक है. ओरिजिनल एंड appellate jurisdiction, इसका मीनिंग क्या हुआ कि ओरिजिनल का मीनिंग इफ देयर इज एनी वायलेशन ऑफ लॉ, ठीक है, रिलेटिंग टू एनवायरमेंट, अ पर्सन कैन डायरेक्टली गो टू एनजीटी, ठीक है, दैट इज कॉल्ड ओरिजिनल jurisdiction. Original jurisdiction means the right of या the power of hearing cases in the first instance, ठीक है, right of hearing the cases in the first instance is called original jurisdiction. Similarly, appellate jurisdiction means when some lower court has passed some order, ठीक है ना, that relates to environment, and then you appeal, okay, you appeal, yeah, you challenge that order in another court, that is called appellate jurisdiction. Here lower court and this one is tribunal. Okay, this is called appellate jurisdiction. तो NGT का both original and appellate jurisdiction दोनों है, ठीक है, ठीक है. Not bound by the civil procedure code, we already talked about it. Appeal against the decision lies in the Supreme Court within 90 days. If one wants to challenge the judgment of NGT, they can appeal in a Supreme Court and not in High Court. But in this case, that person filed a writ petition in the High Court of Madras. Now, it can provide for relief and compensation that we already studied. Restitution of property damaged. Restitution of property damaged means, for example, if a government is trying to relocate people from some core area or buffer area of some national park, okay, in that case, if people filed a case in NGT, okay, and NGT can then grant, if the NGT sees the merits of the case and NGT favors people, then it can grant the restitution of the property damaged. Restitution means कि again the government will have to re-erect the property, give back the property to the people, okay. And restitution of environment. Restitution of environment मतलब conservation of environment basically. It can also provide for these things. Penalty for non-compliance is up to fine up to rupees 10 crore and imprisonment up to 3 years and both. ठीक है. A very important thing is कि which are the acts covered under the NGT Act 2010. The first one is Water Preservation Control Act 1974, 1977, Forest Conservation Act 1980, Air Prevention Control of Pollution Act 1981, EPA 1986, Public Liability Insurance Act. Now, why is Public Liability Insurance Act covered? This is the act through which NGT awards compensation. Okay. The Biological Diversity Act 2002, BD Act, the act we studied very recently. And one important thing is the Wildlife Protection Act 1972 and Forest Right Act 2006 have been kept out of the purview. तो ये बहुत important laws हैं. Forest Right Act 2006. Forest Right Act has been enacted to grant the right of residence to people who have been living in the forest traditional forest dwellers को right of residence forests में मिलने के लिए, ठीक है. We have discussed FRA 2006 at length in one of our video lectures. You can go through the channel list and you can see that. So, but these two acts which are very important have been kept out of it. Okay? So that limits the authority of tribunal. If Forest Right Act 2006 was also kept within the tribunal, then it would have been much better, because the tribunal is mandated to dispense of cases within 6 months. Okay? That would have been a very expeditious hearing of the cases that relate to the Forest Right Act 2006. Okay? So this is a very important note, that Wildlife Protection Act 1972 and FRA 2006 have been not covered under the NGT. Matlab NGT cannot adjudicate on any matter related to Wildlife Protection Act 1972 and Forest Rights Act 2006. That is all for the NGT, and we understood that NGT, there is no subsidiary bench of NGT. All the benches, whether south, central, northern, western or eastern, have equal powers with respect to jurisdiction or territorial jurisdiction, and there is no principal bench. And Madras High Court has struck down the notification of 2017 that was issued by the government in favor of NGT. Okay.